Ready to begin.
Okay, thank you very much. Welcome everybody. It's great to have you here today for today's presentation on keeping Canadians safe, emergency legislation in Canada. We have a wonderful turnout. Thank you all for participating today, and I'm sure there'll be others join us as we move along. My name is Doug Moen, and I'm the Executive Director at Johnson Shoyama Graduate School of Public Policy. I'm pleased to be the moderator today, and I will just say at the beginning, thank Karen Jastor-LaForge, who is managing all of the technical aspects of this event and always does a spectacular job. So JSGS is a provincial center for advanced study and research in public policy administration, where we are a partnership between the University of Regina and the University of Saskatchewan, for those who are not familiar with the school. We're very pleased today to be working with the College of Law in partnership, which is obviously at the University of Saskatchewan. This time, I would also like to acknowledge that while today's event is taking place online, JSGS's physical home and that of the College of Law is located, in the case of JSGS, both on Treaty 4 and Treaty 6, College of Law's Treaty 6 land and the traditional homeland of the Métis. To help our event run smoothly, we ask that all attendees stay muted and turn off their video during the presentation and during the Q&A portion of our event. I'll provide detailed speaker instructions in just a minute, and then each speaker will have 15 minutes to present thereabout. Following the talk, our panel will entertain questions, and if you think of questions during the presentation, please use the Zoom's chat function to send your question to Karen Jastor-LaForge. That's Karen Jastor-LaForge. She's on my screen right at the top. During the Q&A, we will then call upon you to ask the question. But if you submit the question, it'll be sent to me and I'll call upon you to ask it. We'll see if that works. I've done this in the last few days with a very large group and it worked out fine. Please note that as with all of our public lectures, this presentation is being recorded and will be available for viewing on the JSGS website. So today, Johnson Shoyama is pleased to welcome Senator Brent Cotter, Felix Hoehn, and Barbara von Tagerstrom for a discussion on emergency legislation in Canada. Brent Cotter is a former dean and current professor at the College of Law at the University of Saskatchewan. He served many roles in the government of Saskatchewan, including Deputy Minister of Justice and Deputy Attorney General, as well as Deputy Minister of Intergovernmental and Aboriginal Affairs and Deputy Provincial Secretary. In January 2020, he was appointed as an independent senator to the Senate of Canada. Barbara von Tagerstrom has been a member of the College of Law since 2005. Previously, she worked at the Supreme Court of Canada, the University of Alberta Health Law Institute, and the University of Canterbury School of Law. She holds a PhD from the University of Cambridge. And her main areas of teaching and research are health law, public health law and policy, food and drug regulation, and tort law. Felix Hoehn is an assistant professor and has been teaching in the areas of property law, administrative law, Aboriginal law, and legal research and writing at the College of Law. He is a contributing editor of the Canadian Native Law Reporter and a part-time member of the Saskatchewan Municipal Board. He is the recipient of many awards, including the Provost Outstanding Teacher Award for the College of Law in 2016, the Scholarly Writing Award from the Saskatchewan Book Awards in 2013, and the College of Graduate Studies and Research Thesis Award in 2011. So we're looking forward to a really interesting and engaging discussion today, and I want to turn the floor over to our first speaker, Brent Cotter. Brent, over to you.
Thank you, Doug, and thank you, Karen, and welcome to all of you, those of you who are joining this presentation. Each of us, I think, has put together a PowerPoint presentation, and I'll try and use that as a bit of a guide as we work our way through this. And hopefully Karen and I are well enough coordinated that she holds the switch in changing the slides. The structure of our presentation as a group is that I'm going to speak a bit about the federal emergency legislation that exists in Canada, primarily the Emergencies Act. And Barbara is going to speak predominantly from the perspective of provincial jurisdiction and legislation, and Felix predominantly from the perspective of municipal legislation and authority, although there's obviously significant overlap. Can we go to the outline page next, Karen? Next slide, thank you. I've set out my remarks in basically 5 categories, and I'll try to be brief about all of them. I should say at the outset, though, that as you probably will appreciate, as much as the Federal Emergencies Act is interesting, it may prove to be the least relevant part of the conversation. Partly, I think, because as we are addressing the pandemic that presently exists, provinces and municipalities are coping, though it's a great challenge. And there are certainly resistance from a provincial perspective as to the wisdom or need for the Emergencies Act to be put into place. That having been said, I'm going to speak a little bit about it in any event. The first observation, as many of you will know, is that the Federal Emergencies Act, passed in 1988, is actually a transition from the War Measures Act, which had been in place for perhaps 75 years or so or more up until 1988. Specifically, the War Measures Act had a focus on war and insurrection, as many of you will know. It also had a very limited consideration of civil and human rights in relation to it. It provided very generous authority to the cabinet and great deference to the cabinet in its management of war and insurrection circumstances. And as many of you will know, its exercise in 1970 came under subsequently significant criticism when it was initiated by then Prime Minister Pierre Trudeau to address the FLQ crisis. All of that led to work to create and establish a somewhat more considerate and more democratically blessed structure for the dealing with emergencies. Can we go to the next slide, Karen? You'll see here, I mentioned the War Measures Act language, constraints that were introduced more specifically, and I'll show you some passages in a moment that address the degree to which the Emergency Act of 1988 is expected to be respectful of and subject to the Charter of Rights and Canadian Bill of Rights. There's language that's more specific about the creation of emergency, and we'll come to that in a second. There are now categories of emergency under the Emergencies Act. There are requirements now of parliamentary approval if an emergency is declared by cabinet, and some express limits on the authority of the cabinet if that should happen. Maybe the next slide, and we'll talk a little bit about what constitutes a national emergency and a public welfare emergency. As many of you will know, there has been dialogue underway, at least as between and among First Ministers concerning the declaration of a national emergency. The legislation in Section 3 describes what would constitute a national emergency, that is an urgent or critical situation of a temporary nature, seriously endangering lives, health, safety of Canadians, and exceeds the capacity or authority of a single province to be able to deal with it. And as you'll see at the bottom, I tried to highlight this in red, cannot be effectively dealt with under any other law of Canada. So that's a national emergency, which covers all of the categories of emergency that are set out in the Act. The next slide, Karen, focuses on one of the four types of emergency, and this is a kind of a new category of emergency subsequent to the War Measures Act, that is public welfare emergency. It itself is defined in the Act and focuses on an emergency that is caused imminently by disease in human beings, resulting in danger to life. I've highlighted social disruption, so serious as to be a national emergency. So in a certain circumstance, the new Emergencies Act, new in 1988, seemed to presage the kind of circumstance that might be what we are experiencing now or could come to experience in the near future. Nevertheless, as I say, unlikely, I think, to be called into play this time around. The next slide, Karen, talks about the exercise of the emergency authority that is in the declaration of a public welfare emergency. The structure of this is that in circumstances where the cabinet, that is governor and council, believes on reasonable grounds that such an emergency exists and is of the belief that temporary measures are necessitated, they may proclaim and essentially declare an emergency to come into existence. With respect to public welfare emergencies, you will see Section 14, which is a qualifier, which requires consultation with essentially the cabinet of each province prior to an emergency being declared. The requirement here, I think, highlights the degree to which, especially in the context of public welfare emergencies, the degree to which a national emergency declared could lead to federal orders and regulations interfering with the authority of some provinces and sometimes get in the way of coordinated effectiveness in dealing with an emergency. The next slide identifies what the contents of a declaration would have to be. One is requirement that it state the state of affairs constituting the emergency, special measures, temporary measures that are anticipated being taken, and if it turns out if it's limited to a portion of the country, identifying that scope as well. So in this sense, there's a greater precision required of the cabinet in terms of the declaration of the emergency than was the case previously. Sorry, somebody must be phoning me. I just ignore that if we can. With respect to the next slide, Karen, if you can go to it. The next slide identifies the exercise of the emergency authority and the scope and limits of the authority. And you will see this is in the whereas clauses in relation to the Emergency Act, a description of the limits of the authority focusing on any measures being taken being subject to the Canadian Charter of Rights and Freedoms and Canadian Bill of Rights, and having regard to the International Covenant on Civil and Political Rights. The next slide also identifies limitations with respect to the Act, that is, that the Act shall not be construed so as to confer on the Cabinet the power to make orders and regulations that would themselves alter the Emergencies Act or interfere with detention, imprisonment, or internment of Canadian citizens or permanent residents pursuant under the definition of the Immigration and Refugee Protection Act. In some respects, you're trying to protect against issues that were raised about internment and the dealings with individual people in previous declarations of emergency in the past. What I think is important as well is that the next section, which addresses the exercise of emergency authority. Here, the scope and limits of the authority are set out in the Act itself in Section 8. I've tried to highlight some of them in the material that you have before you, which identifies the scope of the kinds of activities or initiatives that the Cabinet can undertake by order or regulation. And you can see that they are quite extensive, including what many would constitute as a compromise or interference with provincial jurisdiction with respect to property rights, the movement of rights, regulation of goods and services, etc. A fairly extensive authority, so if implemented, would provide the federal cabinet with remarkable reach, I think, with respect to federal jurisdiction. The next slide speaks as well to that, and you can see again a very significant set of authorities, and I think anticipates the ways in which federal authority could supersede provincial authority if an emergency, a public welfare emergency were declared. The next slide as well addresses the way in which this probably would come to be interpreted in federal provincial constitutional terms. I'm not an expert in this area, and I know some of you who are online are, so I'll be a little bit cautious in what I say, but I think it's fair to say that when a federal emergency is declared, this provides significant authority for the federal government to overreach the boundaries of what would normally be its federal jurisdiction, enabling it to address the circumstances of the emergency and in ways that would compromise or override existing provincial laws. It certainly was the case that there was a significant amount of federal deference, judicial deference to the federal government under the War Measures Act, and one would anticipate, although these are different circumstances, whether that would apply again in the circumstances of a public welfare emergency. And I've set out on one of the slides, the number of which I don't have, is a passage from an old case that related to the War Measures Act and the degree to which it interfered with and overrode provincial jurisdiction in some particular areas. I've also wanted to say a word or two about oversight with respect to the federal emergency legislation, which is headed as category number 4, oversight. If we're there, Karen. I made 2 observations here. One is that there is a degree of oversight available to the courts, particularly in the context of violations of the Charter and Canadian Bill of Rights. There's also a requirement of reasonableness with respect to the declaration, although I think it's fair to say that the courts would likely give broad deference to the cabinet and to Parliament, and particularly since Parliament provides oversight, and that there are built-in constraints to the Emergencies Act itself in latter parts of the Act, sections 58 to 62. The other part, which actually was the place where I began in looking at the Emergencies Act, related to the degree to which there is greater parliamentary oversight of these kinds of emergencies than existed under the War Measures Act. And unusually, and if I may say this from the perspective of the Senate, a co-independent authority of the Senate, not so deferential to the House of Commons as is usually the case in Senate responsibilities. I just will highlight that there's a requirement that the Government of Canada table its proclamation and obtain an adoption, that is confirmation of the declaration by the Houses of Parliament, and the power within each of those Houses of Parliament individually, independent of one another, to negative the emergency or amend it or revoke it at any particular time. There's a process and numbers required to initiate such a process, but an authority within Parliament to bring the emergency to an end and not rely on Cabinet's judgment on that. As well, all of the regulations and orders that are initiated pursuant to the emergency are required to be tabled before Parliament, or in the circumstances of what are sometimes thought of as secret orders or regulations, probably mainly in reference to war and insurrection, presented to a separate, independently constituted parliamentary review committee for their consideration and potential rejection. And finally, at the end of the whole process, a requirement in the case of a declared emergency for there to be an inquiry undertaken and reporting back to Parliament after a period of time. My last set of observations, and here I don't want to overtake my colleagues' time, is the question. I'll just kind of skip over the next page of oversight, if I might, Karen, and say a word or two about what I've called non-emergency emergency legislation. The circumstances that we're facing as a country presently are virtually unprecedented in peacetime. And these are presented challenges of a social and economic and health nature that are really quite remarkable. And to the credit, I think, of the federal government, however you view it politically, and to the many professionals who've worked relentlessly to put together a response to the pandemic, I think our hats should go off to them in really remarkable achievements to try to stabilize our economy, address the health needs of Canadians, and enable us to have a decently good shot at a prosperous future, both in terms of health and social and economic terms. One of the things that the Government of Canada has done in that respect is passed two very substantial economic, let me call them non-emergency type emergency packages. One was Bill C-13, adopted in late March. The second was Bill C-14, adopted only about a week ago, I think on the 11th of April. I mention this because in some respects, the broad base of initiatives that are captured under that legislation is probably the most enormous in terms of financial circumstances and spending by the federal government in peacetime history of the country. And I do observe that there was an effort by the Government of Canada to extend that authority even beyond what would normally be thought of as, let me call it, comfortable in a non-emergency situation. And I've produced for you on one of these pages, the non-emergency emergency legislation page, one of the pieces of that bill that was introduced initially and subsequently amended and withdrawn, which is Section 8 of the initial Bill C-13, which would have given the Cabinet the power over the next 21 months to make changes to any specific or specified tax law in the country by order or regulation, and authorizing those orders or regulation to override any legislation that addressed those tax laws. And the only oversight that would be required would be for the finance minister to table a report to Parliament if those orders and regulations would have continued past the end of 2021. It felt to me like something of an overreach that would be much more consistent with the actual declaration of an emergency, but done in this non-emergency emergency way. I think it made a number of people uncomfortable. I would include myself in that, and that I would call it overreaching piece of legislative authority was withdrawn. As I say, as in my concluding observation, I think it's unlikely that we will move to the need for this. As many of you will know, the premiers have indicated that they don't believe that it's necessary or wise for an emergency declaration of this nature to be made, a public welfare declaration. And I think we are hopeful, at least, that we won't need to address the somewhat complicated, interesting, but for the present time, theoretical questions that arise out of the federal legislation. Thanks very much.
Thanks, Brent. I now would go to, really appreciate, Brent, you framing things up for us. And now go to Barbara von Tigerstrom to take us into the provincial jurisdiction and perhaps build on Brent's description of the federal.
Okay, thank you. Can everyone hear me? Doug, can you hear me?
Yes, I can. Yeah, that's great.
My piece of the puzzle is the bits in between, which is actually a very complex puzzle in itself. So I'll do my best to summarize briefly what is a fairly complex legal framework. So in trying to organize some thoughts around this, I broke it down into the 4 questions you see here. So looking at what is the legal framework that we have and what are some issues that might arise with respect to that legal framework. I'll just say by way of preface, you'll see on the slides, I've got a few quotations from the SARS Commission reports that I have found useful in thinking about how to critically assess the legal framework that we have. Obviously, SARS although it was quite different in some respects from the challenges we're facing now, was really our best, if you could call it a dress rehearsal, for what we're currently experiencing. And so the reflections after SARS in terms of, what were the gaps, what are some issues with the legal framework that we had in place at that time, I've found very helpful. So I'll highlight a few of those. So looking at where do these powers come from? What is their source? Who can use them? How do we enforce the orders that are made using those powers? And then what limits are there? So that could keep us busy all day. I'll try to just highlight a few points under each heading. So if we go to the next slide, I think it's useful to start, and this will tie into some of what Brent was saying. If we are talking about emergency measures, it's useful to reflect a bit on what the nature of an emergency is and how that affects the kinds of powers we have and the way that they're used. So if you think of what defines an emergency, it's a state that is, there's some kind of serious threat. There's a seriousness threshold there, the urgency of the threat and measures needed to address it. And we think of it as temporary in nature. So an emergency may go on for some time, but it's not a state that should be considered indefinite. And we see those written into the definitions of emergencies in the various pieces of legislation. Emergency powers, we can think of, obviously, are the ones that then we would use during that temporary state. But they're also powers of last resort, not in the sense necessarily that we're going to try everything else first. That would be disastrous, but in the sense that, or potentially disastrous at least, but in the sense that other everyday existing powers are not adequate. So I think of them as powers of last resort in that sense. So, the next step is to think about what makes a public health emergency different or special, or what distinguishes it from other emergencies. Every type of emergency is going to have its own challenges, and so it's interesting, as Brent was highlighting, in the Federal Emergencies Act, we've got sections of the act dealing with different categories of emergencies as if they were different animals, which they are in some senses, but not in others. So a public health emergency, this comes out really strongly in some of the commission and other writing around SARS, and anyone who really pays attention to public health emergencies, is the complexity and uncertainty attached to them, is of a different order of magnitude than something like a disaster, in the sense that sometimes it's not clear when it began or where it began, at least at the time. In retrospect, we can see that, but at the time it's difficult sometimes to know when the emergency has started. And as we're experiencing and will continue to experience for some time now, I think, difficult to tell when is it ending, right? The current predictions are that COVID-19 pandemic will continue for at least months, if not years, in some form, whether it's and most likely a combination of subsequent waves and continuous low-level transmission. So when does the emergency end? When does a new one begin? These are questions that we're all grappling with. But the level of uncertainty attached to all of that is more than I think we would see with some other types of emergencies. So public health emergencies are different in that sense. Maybe not categorically, but as a matter of degree for sure. And we'll see that as an issue when we look at the accountability and some of the oversight mechanisms for using those powers. At the same time, though, it's also clear that if a public health situation becomes a true emergency, it's not going to be just about public health. And so that's where some of what Brent was talking about as the non-emergency emergency measures come into play. All of the collateral damage, if you will, all of the secondary effects of the measures. The primary emergency measures are the ones that we're taking to try to minimize transmission and keep people from dying. But all of this fallout from that, all of the secondary effects create a larger state of emergency. So if we go to the next slide, you can see what that means is that we need multiple pieces of the puzzle to deal with these situations. And so I've tried to break this down. This is a very busy slide and I won't go through it in detail, but just to try to explain how this is broken down. In the first row, we have what I would call general or everyday powers at the federal or at the PT level. So these are the ones that are being used all the time without much attention being given to them in public health legislation, which at the federal level, we're looking primarily at the Quarantine Act if we're looking at infectious diseases, or the public health statutes at the provincial territorial level. So these are all the powers that exist and are used every day to screen and test people, to isolate them and detain them if necessary. The difference being, compared to the next row, that at this first level, the everyday orders would be usually for an individual, right? So we have ordering an individual to subject themselves to testing or treatment, to isolate themselves if they're infected with a contagious disease. So if we move to the next row, these are the emergency powers that are still within the realm of public health legislation. So not emergency statutes, but the Quarantine Act at the federal level and the public health statutes at the provincial territorial level. So you'll see some of the same types of things in these powers. The difference being that we're now imposing them population-wide or on a group of people. So one of the things that became apparent, a big gap in the Ontario public health legislation during SARS, was that there did not appear to be the ability to do a quarantine or isolation of a group of people as opposed to an individual. And so you might say, well, just phrase your order so that it applies to lots of different people. The problem being procedurally, in that first row of everyday powers, we have procedural protections, delivering the notice to someone. They have a right to challenge it. Each individual order has to be reviewed. We have a whole set of protections that when you start looking at it on a class or population-wide level, just become completely unworkable. So we have some of the same powers in the emergency public health powers, that would be the same, but at on a larger scale. And then we have measures that would be some of the types of things we're seeing now. So restricting travel, limiting or prohibiting gatherings, authorizing or requiring people to provide services, procuring supplies, all of those types of things. So an expanded set of powers. And then on the third row, again, at both the federal and the provincial territorial level, we see the capital E emergency powers, if you will, in emergency legislation. And so Brent has already talked about what's available for a public welfare emergency under the Federal Emergencies Act. At the provincial territorial level, we have, you'll notice some overlap in the lists between public health emergency powers and emergency powers under emergency statutes. Similar types of things, closing premises, regulating or procuring goods and services, limiting travel, etc. And so what we're seeing is a mixture of these pieces, except for that bottom left corner being used currently. So I'll say a few words about that on the next slide. Just one observation in between is that, of course, what's missing from that last 6-part classification is obviously local and municipal powers, which Felix will be talking to us about, Indigenous governments, and then other types of legislation, especially those dealing with those secondary effects that we were talking about. So as far as what's been used to date, not the Federal Emergencies Act, of course, as we were just talking about, the emergency orders we've had so far have been under the Quarantine Act. And so those are the ones that have now restricted travel. They imposed quarantine when we had those first repatriation flights. All of those issues have been dealt with as Section 58 acts under the Quarantine Act. Some of the travel measures, so the current requirement to wear a face mask during airport screening or on a plane, that's actually an order under the Aeronautics Act. And we have the restrictions on cruise ship travel and disembarkation of passengers and things like that. So a mixture of other statutes to deal with travel, essentially, and travel protections. So at the PT level, it has been quite a mixed picture. And again, partly because we saw that overlap of powers under the emergency or epidemic powers under public health legislation and emergency statutes. Those lists contain a lot of the same things, and they are typically open-ended. That means that in many cases, the provincial authorities would have a choice of which statute to use. And some have used just public health statutes. They haven't declared a general provincial state of emergency yet. Those are in a minority, but there are still a few. I'm not sure if there are any left that haven't used public health, that have just used emergency statutes, although Ontario overwhelmingly has. More often, as here in Saskatchewan, they're using both, but in slightly different ways. The relationship between the public health orders and the emergency orders looks a little bit different in every jurisdiction. So it's interesting that the variation in which powers are being used and by whom, there's a lot of variation, but the substance of the orders, if you've been following the news or looking at or tracking these, are fairly consistent with a couple of exceptions. So limits on gatherings, a bit of variation on the size, but all have some of those limits. Closing non-essential facilities and businesses, closing the schools and other educational institutions, mandatory self-isolation for people who are contacts or known to be infected. Mandatory self-isolation for international travelers returned to the province or territories is pretty much universal as far as I can tell. Where it's a bit different is whether mandatory self-isolation applies to travelers returning to the province from another place within Canada. about half of the jurisdictions have that. And then also roughly half have some form of restrictions on travel within or to the province. So you might ask then, if there's that much variation in terms of who's using which powers, but we're ending up with similar orders, then what difference does it make which statute you use? One of the reasons it might make a difference is who has the authority to make the order. So if we go to the next slide, you'll see, I'll come back to the quotation at the top in a moment, but that typically the general emergency powers will be cabinet or someone acting on, here in Saskatchewan, it's the premier has been designated that authority. Whereas typically, and I say this cautiously because it varies a bit, it'll be the chief medical officer of health or equivalent who has the power to make orders under public health legislation. And so why would we care about that? There is an opinion, which is in the quotation at the top of the slide, that when it comes to the public health measures themselves, so the measures that are directly attempting to restrict transmission of the disease, that those are best left to the public health experts, if you will, so which would be the chief medical officer or equivalent. Whether they are always ever, as the quotation suggests, they should be free from bureaucratic or political pressures is, I think, optimistic. And we could debate whether that is even possible, and if it is that a good thing, right? Are these decisions not always inevitably to some degree political? So we can maybe discuss that if you like. Next slide. The other difference in why it might matter which statute you've used is the enforcement powers are different. And so it might make a difference who's actually doing the enforcement, what the penalties are, and that kind of thing. This is one area where we've seen a lot of activity across the country, a combination of plugging gaps, where in some cases it seemed that orders were made without it being very clear who had the authority to do the enforcement. And then in some cases making adjustments to that. So very commonly putting some kind of ticket option in place as a more practical way of dealing with some of, violations of the orders. So last, if we go to the next slide, is a set of really big questions, which I'm going to talk about in about 30 seconds, of what limits exist. And I'm guessing there will be questions about this, so I'll just highlight a few things. The obvious constitutional constraints, division of powers, charter issues have been talked about a lot. I get a lot of questions about this. Mobility, the mobility rights in Section 6, I think maybe not playing as big a role as some people think it is, because it applies mostly to the right to take up residence in a province, rather than me wanting to, go visit family in the neighboring province and that sort of thing. One thing that it does, that Section 6, the first part of it does apply to, is the right for Canadian citizens specifically to enter Canada. And there was an order in place for a time. It's not in force anymore, but for a couple of weeks, there was I think it was an Aeronautics Act order that prevented even Canadian citizens, anyone at all, from entering Canada if they, from boarding a flight to Canada if they had COVID-19 symptoms, which would be a clear infringement on Section 6.1. Section 7, of course, has been discussed a lot, and so things to think about, and we may discuss during questions, the scope of what liberty rights may be infringed. Again, understanding that liberty doesn't necessarily include the freedom to do everything I want to do. security of the person, potentially in some situations, and then of course all of those subject to principles of fundamental justice and all of the charter issues subject to Section 1. I won't say anything about judicial review, except obviously the potential is always there, despite attempt privative clauses in all these statutes. There's also some variation that's interesting in terms of the protection from liability under emergency and public health statutes. If anyone's interested, I can talk about that a bit in the Q&A. Last slide, just to conclude, the key points to just reiterate in terms of all of those oversight mechanisms and the limits on the powers depend a lot on the degree of deference that would be given, especially during Section 1 analysis, for example. And especially if the first one just talks about the uncertainty, which they were worried about in SARS, and I would say the uncertainty we're dealing with now is even on another level. The second point, Dr. Bonnie Henry, who is now well known to everyone, I think, who's been following the news, but she was with Toronto Public Health at the time. The main point of her testimony was that you can't, and if we're thinking of proportionality, it's almost impossible to get the Goldilocks just right point, right? That you always, if you're doing it right, actually you will appear to be overreacting. And so that is something that the courts would have to take into account, I think. So I've already gone on too long, so I will stop there. Thanks.
Thank you, Barbara. That was great. So Felix, if we could turn to you now, talking about the interplay between municipal and provincial.
I guess it helps if I turn my mic off mute. Thank you, Doug. Yes, I'd like to speak to municipal duties and powers, mainly municipal powers, and I have a bit of an outline on the next slide, Karen. And so just to begin with, for most of you, I'm sure it's a review, not an introduction to municipal authority and where local powers come from. And then just a little brief look at the past and kind of the bad old days when local governments didn't get much respect from either the legislatures or the courts. And then a look at the present, where that has to a large measure changed, and the important municipal role is recognized in terms of local duties to plan for and prepare for and play a role in emergencies, and also local powers, although as we'll see, a little less consistent on the powers front than on the duties front, perhaps. And then I will make an argument as to why we should have local powers in emergencies. So just to begin with then, on the next slide, begin the review of local governments. The most crucial thing to understand, of course, is that local governments have no constitutional status. They gain all of their powers from provinces or territories, although I'll be talking about provinces today. And there's lots of different authorities for what this slide essentially says. But what it essentially says is they're animals completely controlled by the province. They can do only what the province tells them they can do. Their very existence is subject to the will of the province. And of course, the province can always remove powers or override powers by legislation. And then on the next slide, this is perhaps more of a historical rule, although technically I think it still exists in the courts. This is the short version of Dillon's rule from the Supreme Court of Canada, or as the Supreme Court of Canada described it in 1993. And but it has the gist of it, which is that courts would narrowly interpret grants of powers from the provinces to municipalities. And when you combine that with certainly at that time in 1993, it was still the kind of old model of municipal legislation, which granted powers in very narrow terms. People have called it a laundry list of powers, and were very narrow and specific. And if the municipality didn't have the power to do the exact thing they wanted to do, well, then they couldn't do it unless they asked for more powers and changes and amendments to legislation. And so since, moving on to the next slide, since those powers were often wanting, and municipalities sometimes wanted to do things that they thought were very important, but they couldn't find a specific grant of authority to do them in, that's where the emergency powers included in some or most of the municipal legislation came to be used, or we might say abused, for things that were not really intended to be used for. And there's a bit of a colorful history of that. One example from 1962 is to exclude the Sons of Freedom sect of Duke Force from the municipality of Kent. And probably not a proud moment, maybe a reflection of its time, that the court at the time actually thought this was a legitimate emergency, that there were perhaps up to 1,000 members of the sect, including, they were families and children, wanting to come to the municipality of Kent because 68 members of their sect were being held in a federal prison within the municipality at that time. And maybe the municipality or even the court's view of the emergency of the situation was influenced by the preamble to the bylaw, which described the Sons of Freedom sect as addicted to nudism, arson, illegal use of dynamite, and explosive devices. So although the judge would have gone along with the idea or was prepared to accept this was an emergency, he found this was invalid because it conflicted with federal criminal powers. A valid use of emergency powers, perhaps surprisingly, if we think about, as Brent and Margaret talked about, what is an emergency, the court did accept there was an emergency in the city of Victoria because there was a threat to a number of heritage buildings, and the municipality had no other way of protecting the buildings than to reach to their emergency powers. Another invalid use of, or attempted use of the emergency powers was actually a dangerous dog bylaw in the township of Langley in BC. And to move that to the next slide there, please, Karen. The township based its dog bylaw on an emergency power that was broader than most BC municipalities have today, but Vancouver actually has virtually the exact wording still in its Vancouver charter that delegates powers to that city. And you can see it says where the powers conferred on council are inadequate to deal with an emergency, the council may by bylaw, by a vote of at least 2/3 of its members, declare that an emergency exists and exercise powers necessary to deal effectively with the emergency. And certainly some of the discussion in the Coopers and Langley case, and I would highly recommend that case to you if you're in isolation or at home and are looking for some reading. Read that case. It's really quite entertaining. One issue the judge really does grapple with is what is an emergency, and can there be an emergency in relation to dangerous dogs? And Karen, the next slide, I think indicates kind of the mocking tone that the judge takes of the idea that this bylaw passed in 1988 could still years later deal with a purported emergency that he says is kind of a War Measures Act for municipalities, which in some sense it is, but saying that in the context of the present case, one has visions of the great dog insurrection of '88, British bulldogs, German shepherds, Russian wolfhounds and the like, huddled in secret kennels presided over by an imperious Pekingese, plotting to overthrow the lawful authorities by force. And then to go on to the next slide where he continues, and I apologize, but I just couldn't resist a couple of little nuggets from what he says. He says, I might admit mea culpa that a few people when elected to lofty office sometimes, rarely of course, when they do not have the power to act, often assume that they do have, or wish that they had, or in pursuit of their highest ideals, believe that they should have, or as otherwise they are convinced the world will not be saved. And this is perhaps appropriate as a cautionary note. And I am going to be making the argument that municipalities should have emergency powers. I acknowledge that there is a history of abuse, so we have to be aware of that possibility. And as we move to the present in my argument that municipalities deserve kind of respect they're getting generally in the law, and that should carry over to the emergency sphere. So on the next slide, I have sort of the opening of kind of the modern view of municipalities and the law, where here the Supreme Court of Canada in the Spraytech case in 2001 recognized and said that lawmaking and implementation are often best achieved at a level of government that is not only effective, but also closest to the citizens affected, and thus most responsive to their needs, to local distinctiveness and to population diversity, something that has been called the principle of subsidiarity. And so this comes at the beginning of the 21st century, and at the same time as there is a general movement across the country in passing a new generation of statute where municipalities are granted powers in broad and general terms rather than the narrow specific terms of the past. And at the same time that was happening, and has happened now virtually everywhere across the country, the Supreme Court of Canada in a later case in 2004 said, okay, there's now new legislation and we need a new approach to interpret that. We're going to take a broad and purposive approach to interpreting municipal powers because they are important and they require flexible powers. So that sort of sets the stage, I guess, to where we are today in terms of how municipal governments are looked at in the law. And they're seen as an important part of a response to an emergency. So on the next slide, I just briefly summarize, at least in Saskatchewan, what duties are imposed on municipalities, of course, by provincial legislation, in terms of what they are called upon to do, because they are recognized as being in a good place to do that. So they're required to have an EMO, emergency measures organization, a coordinator, a planning committee, and a plan. And then council in the first instance is responsible for taking control in an emergency unless the minister assumes control. And other provinces have similar provisions. I've mentioned here the Alberta Emergency Management Act, which is similar. But along with duties, local governments also have been granted powers to deal with emergencies. And so on the next slide, I have three categories of local powers. First of all, those broad and general grants of power in the modern legislation that I've referred to, and I guess we could call those non-emergency emergency powers if you like, because they're powers there all the time, but they could be used for an emergency purpose. And the very recent example of the Laloche curfew bylaw is an example of that, because they specifically in their bylaw drew upon one of those general grants of power, health, safety, and general welfare kind of a power. Secondly, powers under provincial emergency legislation, the Emergency Planning Act of Saskatchewan, the Emergency Management Act, for example, in Alberta. And two municipalities in Saskatchewan used the authority under the Emergency Planning Act to declare local states of emergency that, well, I'll talk about in a minute, were very short-lived. And then thirdly, there are emergency powers in municipal acts, which sound a little bit like that Coopers and Langley, BC, Vancouver type of clause, where it just simply allows whatever actions or measures are necessary to eliminate the emergency. Although I don't know of any example where that's been used recently. So looking at Regina and Gravelbourg on the next slide, specifically under the Emergency Planning Act, Regina banned group meetings of over 5 people and ordered the closure of dental offices and most retail stores. And then Gravelbourg also pretty much required all businesses to close with a maximum of 5 people in the building. That is not closed, but for drop off or pickup only, including grocery stores. And now both of those orders were canceled by the province within days. the province wanting a consistent approach across Saskatchewan. Interestingly, I think, meanwhile in Alberta, if we go to the next slide, dozens, probably, I have lost count, but there's a great number of municipalities there who declared local states of emergency due to COVID-19. Interestingly, the Alberta legislature took exactly the polar opposite approach of Saskatchewan. And on March 20th, they passed a special amending bill to allow local states of emergencies to remain, even if Alberta wants to use its powers under the Emergency Management Act, which it hasn't yet. It's just used powers under their health legislation. But if they wanted to use those powers, they didn't want the local emergency orders to automatically end, so that they could remain in force. And that received unanimous consent for 3 readings in one day, and the statute came in force the same day. And on the next slide, we'll see that the debate, such as it was in the Manitoba legislature, actually hearkened or reminded us a little bit of that principle of subsidiarity, which was expressed that, you know, municipalities deserve the freedom and the opportunity to make the choices that fit them best based on their detailed knowledge of communities. Municipalities know what's best for their residents. We are simply getting out of their way and letting them do it. So a very different approach than what we've seen in Saskatchewan. So why local emergency powers? And I have a list that begins on the next slide. I would argue that first, local governments often know what's best for their residents and may be willing to go further than more centralized, larger governments to protect them. We've seen provincial measures, for example, tighten to encompass some, but not all of what Regina and Gravelbourg had ordered first, such as we now have provincial restrictions on dental services, stricter limits on gatherings than there were at the time. The La Loche curfew, of course, is still in effect, and I think the province approves of that from what I've heard. CBC quoted a lifelong resident of La Loche as saying that there was a lot of people out and about, but now it's very quiet. He said people are taking this seriously. So they seem to know what was going to work in that community. So which is kind of what my next point is. Local authorities know what will work in their community. And in Gravelbourg, they didn't allow shoppers into the local co-op store, but rather organized volunteers to deliver groceries. And they may have been a bit ahead of their time. Just within the last few days, there's been a CNN article quoting experts in the US saying that there's too big of a threat to the safety of grocery store workers that really this is the way that they should all be moving towards. And then on the next slide, we have a couple more reasons why I think municipalities ought to have local authority in emergencies. They have expertise in matters they normally regulate, which may not be found elsewhere. So for example, Edmonton's local state of emergency imposed specific restrictions on vehicle for hires like taxis and Ubers, and how many people can be there, where they need to sit, how often they need to be sanitized, that aren't reflected in the provincial measures. Toronto imposed fines, quite steep fines of $1,000 and more for failing to social distance in city squares and parks. And finally, multi-level regulation works for other matters. Why not emergency measures? So in Spray Tech, Supreme Court of Canada said, you know, pesticide regulation can happen at the federal, provincial, and local level as long as there's no direct conflict. And intergovernmental cooperation should be the norm. For example, Calgary and Alberta imposed restrictions on personal service industries the same day. Calgary just removed its restrictions, having seen the redundancy. So I think my time is pretty much up. So I'll just conclude on the next slide by saying that as creatures of statutes, local governments rely on provinces to delegate powers needed in an emergency. Courts and legislatures have recognized the importance of local governments, but this is not being consistently applied to emergency powers. And local governments should have significant duties and powers in emergencies because they have democratic mandates from their residents. They best understand local needs, and they have expertise in matters that they normally regulate. Thank you.
Okay, thank you very much to Brent and to Barbara and to Felix. Those were great presentations. Set the stage for an interesting question period. So what we're going to do is I'm going to ask you to submit your questions to Karen Jester LaForge. She'll just send them along to me, and then I'm going to get, if as long as things are going fine, I'm going to have the questioner ask the question of the individual member of the panel. So Mike has got a question for Felix. Mike, do you want to put your question? And I just asked people to be fairly brief so that we can have a number of questioners. Mike, you're on. If you could take off your mute. Okay, so maybe what I'll do is I'll ask the question, and to Felix, does the fact that there are over 700 municipalities in Saskatchewan change your opinion that municipalities should be allowed to enact emergency measures legislation during a province-wide emergency? Does this not risk creating a patchwork of emergency orders? Felix.
Well, certainly, we have a lot of municipalities in Saskatchewan, and I mean, one thing that you could quite legitimately ask is whether all of, especially the smaller municipalities, have the capacity to appropriately deal with emergencies, not only in terms of fulfilling their duties, but also making decisions and enforcing the kinds of powers that they could have under the legislation. And so I think for the smaller municipalities, I think that is a legitimate question. I think you could also, in terms of your question, talking about a patchwork, I think some people have said, well, it's going to be confusing. I don't know what rules are going to apply to me if I'm a business operator or owner or a resident. And I think that certainly that there is a risk that having different orders in different places and by different levels of government can cause some of those questions. But we do have tribe regulation in other areas. I think we could have it here. We have the capacity through websites and email and so on to and news outlets to inform people about what the requirements are. And also some of that can be alleviated if we have an appropriate amount of cooperation intergovernmentally as to who's going to be responsible for what. And certainly I'm not suggesting that there shouldn't be, certainly when it comes to the Emergency Powers Act, et cetera, even the Alberta new legislation does allow for the possibility that local states of emergencies can be overridden by orders in council if there's a problem with consistency. But hopefully there wouldn't be frequent need to use those powers.
Okay, thank you very much. So we have a question here from Douglas Thompson. Douglas, do you want to make your question? Put your question to the panel.
Well, hello. Hi. Just wondering, with the Emergency Measures Act, first of all, it was great. As far as healthcare workers and the lack of PPE, what options do healthcare workers have, especially if these healthcare workers have pre-existing conditions and they're at risk for, they have pre-existing medical conditions, maybe they're a little bit older, maybe they're a single parent. What protection do they have? And if the Emergency Measures Act that comes in and says, right into the hospital you go, what protection, what options do they have? Is it just a fine, or is it incarceration, or what happens? I mean, just curious, what are the consequences if they get mandated back to work? What emergency measures, there was a PowerPoint slide that said, as far as requisitioning materials and property and whatnot. But I mean, these healthcare workers are going to be very important. But the lack of PPE, and then with the healthcare workers having, some of them may be high risk. I'm just interested in knowing what the thoughts are on that. And thank you.
Okay, thank you. Barbara, do you want to start with that?
Yeah, a couple thoughts. One of the questions is so many different pieces to that. Actually, we could probably talk at length, but
I apologize.
No, it's a great question, but just challenging. because there's so many different facets to it. There have been questions raised as to, again, going back to this issue of overlap between different pieces of legislation, and can emergency orders, they typically can override other legislation, although that's not actually clear in many of the emergency statutes. The big question is, can they override collective agreements? That's also not clear often. And can they override occupational health and safety legislation?
And I'm glad you brought that up. I'm an oil rig worker. I have a right to refuse work.
Yeah.
And actually, I'm, you know, but this is
that's one of the
I'm familiar
tensions.
with.
And again, there's actually quite a bit of discussion that was a big issue during SARS, and so the commission reports deal with that. And interestingly, in the Ontario legislation, unlike others, they specifically say their emergency powers include authorizing people to work, but not, there is no power to force a healthcare worker or any other essential worker to work, which we see those powers in other legislation in other provinces. But in Ontario, partly because of the controversies around exactly lack of adequate protection during SARS, they said, no, that's not a power that the government should have to force someone to work in an unsafe environment. Other questions about what the ethical duties of healthcare workers are, again, we could talk at length, but the key questions would be the extent to which occupational health and safety legislation and collective agreements still protect workers to some degree.
Thanks, Barbara.
I think the biggest problem is with the lack of PPE right now.
Absolutely.
Okay, Brent, did you have anything you wanted to add to this? Sorry, Brent, you're just on mute.
Give me a second.
You're good? Yep.
Can you hear me now?
Yeah, that's good.
My observation is quite limited. It's a very good question, and Barbara focused on the central part of it. The federal legislation, I think, is largely intended to enable significant resources, say, to be moved to a province that was really stressed by these circumstances and doesn't focus. It has a lot of implications for property and civil rights and compensation for people who are moved about like that, but it doesn't specifically address the kinds of questions that the questioner asked about implications for a person's employment if they're being ordered to work, the health risks, occupational health and safety risks.
Okay, thank you, Brent. Now I'll go to Taylor. Tay, you've got a question regarding opportunities for the homeless to have some assistance. Could you put your question? Okay, well, I'll just put it then. Are there any barriers to the province putting in place radical measures to assist with providing shelter for the homeless, perhaps requiring hotels to provide rooms? Who wants to take that on? Barbara, why don't we start with you, and then maybe Felix will have something to add.
Yeah, legally, I see no barrier. The powers are clearly there to requisition and use property if needed, and I would have thought this would be a rational use of it. So if there is a barrier to that, it would not be any lack of power.
Okay, thank you. Felix, anything you want to add? Sorry, you're on mute, Felix.
Sorry, I could say the same thing at the municipal level. There isn't a legal barrier. Municipalities have the broad general authority to deal with various matters, including the homeless. Certainly, municipalities have taken action against homeless people to try and keep them from staying in parks and so on. They could also take measures to protect and shelter homeless people. But I think the pressure has been more on the provincial government to act in that regard than on the municipalities, as far as I've seen. But there's no reason why they couldn't.
Okay, thanks. I'm just gonna, I don't have any other questions at the moment. I'm just gonna, so send in your questions, folks, but just a couple questions that I've got. You know, you all talked a fair bit about jurisdiction, division of powers. So what can the feds do that the with their legislation the provinces can't do? And similarly, what can the provinces regulate that the feds cannot? You know, keeping in mind there's lots of non-lawyers in the audience, and just to give people a sense of where that jurisdictional split looks. Brent, you want to start that one and then maybe go to Barbara?
Sure. Can you hear me okay?
Yes, just fine.
The general framework is that questions dealing with the health of individuals and property and civil rights in the province belong normally in the provincial jurisdiction. There are some sets of responsibilities related to health and public health and standards that Ottawa typically regulates. But in terms of frontline service, this is generally thought of as a provincial responsibility, and we have structured the whole of the framework of funding provinces and federal government and territories to recognize that. In the case of emergencies, I would just add that certainly the federal emergencies legislation starts to bump up against and sometimes overtake those provincial responsibilities, and that's the structure of the Federal Emergencies Act, to create that slightly overreaching authority for sort of national purposes.
Okay, and Barbara?
I mean, there's a lot of overlap in some respects. Generally, like Brent said, we think of, you know, when I think of the day-to-day public health measures, those are mostly provincial. So in terms of infectious disease control, other aspects of public health, we see both levels of government acting. Where in terms of things like mandatory isolation or other containment measures within a province, that would be clearly provincial jurisdiction. If the federal government tried to step in and mandate that, I think that would be overreaching their jurisdiction. The federal quarantine jurisdiction has always been understood to mean protection from infectious diseases and other health hazards at the border. And so, which doesn't match the way the public health folks use quarantine and isolation. It's very confusing. But the jurisdiction over quarantine would be restricting people or goods or animals, whatnot, but here, people entering the country. So one of the questions, and maybe some of our division of powers experts want to jump in on this, but the one area where I wondered if there would be some potential jurisdictional issues is with the provinces trying to either limit entry into the province, including across an international border, or impose mandatory self-isolation for people, for international travelers. It's become a bit of a moot point because almost, I think every jurisdiction in Canada, provinces and territories, have mandatory self-isolation for returning international travelers, but so does the federal order. So they overlap, there's no conflict between them, but a number of provinces introduced that before the federal government did, and it's not inconceivable they might want to continue it after the federal measure ends. And so I wondered whether that would be seen as a provincial intrusion on federal jurisdiction.
Okay. Felix, do you want to add anything to this?
No, thanks.
Okay. All right, so now David Elliott's got a question. How far can the provincial emergency legislation go in overriding provincial legislation? Could it be used to change the provincial election date through an exercise of emergency power? Anybody want to take a run at that?
Brent.
I kind of like the idea where the panelists ask questions of the audience. And there are certainly, I think, some of our people attending this seminar who likely have greater, more powerful insights than me. That largely depends on the nature of the authority provided under the legislation, whether one emergency authority has the ability to override existing legislation or regulations under other statutes. And I don't actually know the answer to that with respect to the Saskatchewan legislation.
Okay, let's, maybe we can go to, play in a similar area. We're just wondering whether provinces can legally prevent other Canadians from entering from another province. Nova Scotia seems to have put some restrictions on who can enter Nova Scotia. Barbara, you sort of alluded to this. Do you want to can you just build on that just a bit?
Yeah, by my last count, about half of jurisdictions have some kind of restriction on intra-provincial travel, either restricting entry to, not allowing anything but essential travel or returning residents, or to all or part of the province. So most recently, Manitoba is restricting travel specifically just to northern Manitoba. Quebec has restrictions on travel both within and to the province, and a number of others have restrictions on traveling to the province. About half of jurisdictions now have mandatory self-isolation for people who've come out of province. So I think it's important to make that distinction, because I would think, and again, our division of powers experts will correct me, I hope, if I'm wrong, but I would think that the provinces are on pretty solid ground imposing mandatory self-isolation for someone who comes, let's say, you know, BC just put in an order for anyone returning to BC from Alberta who's been at the camp where they have the outbreak in northern Alberta. I wouldn't think that there would be a question as to whether BC has that jurisdiction. Sorry, I lost my train of thought. But as far as restricting travel, prohibiting other Canadians from entering the province, I can't see a reason. I haven't been able to find anything that says that's beyond their jurisdiction, but again, I hope someone will correct me if I'm wrong.
Okay, is there any division of powers folks out there who want to make any comment on this? Okay, I'm going to travel more into, oh, here we got a question from Karim Ishmael. Is it within the federal government's reach to use its own Emergencies Act to prevent the opening up of the economy anywhere across the country? Everybody's been getting along up to this point. What if they stop getting along? Are we going to be able to use the federal power to override a provincial direction to open up? Brent?
Well, I think if the Emergencies Act a declaration was made, and particularly if it focused on sort of managing and constraining economic activity for public health purposes, I think there would be that power that would exist. It's a bit tricky, because the idea isn't that you would use that authority in theory, disproportionate ways across the country, but I think to address what would be interpreted as a public health risk, in theory at least, the federal government could do that if it proclaimed the Emergencies Act to be authorized. Creates the kind of tensions that I think one sees in the United States these days regarding opening up the economy versus the public health concerns of doing so. But I think in theory, if it got used in that way, it could be effective.
Okay, thank you, Brent. From EWA, people have said that the use of the emergency powers to restrict movement and fine people who flout movement restrictions is a breach of the Charter. Should the overall health and safety of the majority of citizens be grounds under Section 1 of the Charter to justify the use of such emergency powers? Barbara.
I can start, I guess. Two questions. The first is whether all of the orders that are being made actually do infringe a charter right. And so, as I mentioned very briefly, not everything that limits me from doing what I would like to do is a Section 7 violation or infringement, right? Liberty is freedom from physical constraint. So if I'm actually detained somewhere, I can't leave my house, then yes, that would clearly trigger liberty, but not necessarily all restriction on movement, I would have thought. Then you have to find, some issue with principles of fundamental justice. Is this being done in an arbitrary way? Is it disproportionate? Is it overbroad? In most cases right now, I would say you'd have a hard time making that argument given what we know about the transmission of this disease. So restricting the movement of people who may or may not have the disease, I can't say that that's overbroad given that we know asymptomatic people may transmit the virus. If you get that far, then you get to Section 1. And again, it becomes the main issue would be proportionality. Given the seriousness of the threat and what we know about the consequences of not having these restrictions, I would have thought a court would be very deferential and allow this under Section 1, at least under current circumstances.
Maybe I can just ask a question to build on this. We're going to have a premier today who's going to address the population. Tomorrow there'll be a plan introduced. We've got a very low infection rate in the province. You know, seemingly a very low infection rate. So if infection rates are low in a particular province, whether it's Saskatchewan, Manitoba, New Brunswick, can you continue to restrict citizens from going where they want to go or from assembling? Or if they want to have a drive-in church service in a parking lot, can you, at the church, can you restrict that? I mean, how as this whole emergency evolves, how does that analysis change?
Well, and that's where I think you'd get into more significant questions around proportionality under a Section 1 analysis, right?
Right.
If you even get that far. And again, I'm with Section 7, I think principles of fundamental justice, you'd have a hard time making some of those arguments. But under Section 1, the less, you know, lessening the risk obviously changes the balance as far as the proportionality of the infringements. How serious is the infringement on people's rights versus how serious is the risk that you're trying to guard against? So as the infection rates go down, it becomes harder to make that argument. On the other hand, we know the consequences of letting it get out of hand. So.
Yeah. Okay, Felix, this is going to come to you as a starting point. It's from Carrie Holmes. Do you see one of our biggest challenges as enforcement rather than enabling authority? I'm in Alberta and we are seeing significant exercise of municipal and provincial authority to address health risks. However, it seems the ability or willingness of individuals and businesses to follow this is varied. Although we see this exercise of power, we are seeing continued non-compliance in certain clusters in our cities. In my own view, enforcement ability is limited, which weakens the value of orders issued. How do we strengthen the compliance and effects of our provincial and municipal orders?
That's a good question. I'm not sure I have a brilliant answer to that. Just from news reports I've seen from the municipal context, I think most of the enforcement has been through warnings, but there have been tickets given out. And I mentioned the Toronto example of people, they had a problem with people gathering in parks and civic squares, and they imposed a significant fine. And I think they've, from what I've heard, they've been acting on it. And apparently that's had some effect. But I'm having trouble thinking of other instances of enforcement, just what I've read in the media about the Laloche situation. Again, those are fairly small fines actually that they have there. In fact, the bylaw, I think, indicates a warning first and then a fine of $100 or $150. But it seems to be making an impact having just the bylaw in place rather than having to go through a great deal of enforcement.
Thanks, Felix. So this observation and question, I believe is from Dwight Newman. It's from Dwight, so I assume that's Dwight Newman. Emmett McFarlane in his recent, and this is going to go to start with Brent, if that's okay, Brent. Emmett McFarlane in his recent piece in the Canadian Journal of Political Science series on the coronavirus seems to think provinces would run afoul of 91-2 authority in blocking interprovincial mobility. And Dwight says, I'm not sure I am sold on this, but I'm interested in what the panelists think. So maybe I can start with Brent and then go to Barbara. We've covered a little bit of this territory already.
Right. I think, you know, it's an interesting question, I think, that Professor Newman poses here about what's the reach of provincial sort of, I don't want to call them blockades, but interference. Indeed, I was doing some work in Nova Scotia in March and drove from here to the Senate to be able to be part of consideration of the legislation in late March. And when I came back, I had some difficulty getting back into Nova Scotia for the very reason that they were imposing a degree of restriction at the New Brunswick-Nova Scotia border. My guess in these circumstances is that there would be an enormous amount of deference to a jurisdiction that exercised this authority. And so as a result, although I confess I might be more sympathetic to Dwight's point of view on this, it's somewhat like the discussions that I've been presenting here. It's a little bit theoretical at the present time. Could I just, and a jumping off point, return to your comments, Doug, about if a province elected to reopen the economy sooner, let's say, than the federal government was comfortable with? My own sense is that that might be there might be a degree of political difference, but unless there was a very significant national risk in the doing of that, I think it's unlikely that the federal government has an easy authority, and the Emergencies Act doesn't really seem to reach quite as far as to justify that, because it talks about serious endangerment to life, health and safety of such proportions that a particular province wouldn't have the capacity or authority to deal with that. That's a pretty large statement, and it seems to me highly unlikely that it could be justified or effective unless there was a really flagrant initiative by a province. And in provinces that are close to recovering, it would be hard to make that case, I think.
Okay, thank you so much. Well, to the panelists and to everybody else, we're at the end of our time. I just really want to thank our panelists for, I think, a stellar job in laying out the emergency legislation we're dealing with and some of the various issues that we have to contend with, including constitutional and human rights questions. Thanks for all your efforts in that regard, and thank you for supporting the College of Law and Johnson Shoyama. I'm going to let all of you slip away now. I'm just going to ask Felix and Brent and Barbara to stay with me, and Karen and the rest of you. Thanks again. Have a great day and stay safe out there. Look after yourselves.
Thanks to everyone for involving themselves in this.